Video number 1, how to control the placement of cell towers, small cells, and DOS nodes in your city, county, town, or village. Contrary to what you may have heard otherwise, when Congress enacted the Telecommunications Act of 1996, it explicitly preserved to state and local governments the general authority to regulate the placement of wireless facilities in their jurisdiction. If your local municipal attorney has told you, oh, your hands are tied under the Telecommunications Act, and you can't control these things and you can't turn down applications, you need to get a new attorney immediately. There are two simple keys to exercising the powers that Congress preserved to you under the Act. The first, of course, is that you must enact local zoning ordinance provisions that have permit requirements and other requirements for wireless facilities. So, sophisticated governments for years have required use permits, special use permits, conditional use permits, site plan approvals, and even variances. And they'll set forth restrictions on which district you can put them in, height limitations, setback zones, fall zones, things like that. Most local codes aren't too bad when it comes to that. The most glaring deficiency which most local codes suffer is that you must also impose procedural guidelines. You must give your local boards procedural guidelines to understand how to comply with the 5 procedural requirements which the Telecommunications Act of 1996 imposes upon them. I mentioned that Congress preserved the general power, and that's under subparagraph A of the Telecommunications Act. But in subparagraph B, Congress enacted 5 essentially procedural requirements. And the truth is, most local governments on most local boards always violate those requirements because they don't know what they are. And you can't comply with procedural requirements when you don't know what they are. So you must amend your code to put them in there. It's not a question of having the power. You have the power available to you. You must simply understand how to exercise it. Now, if you think you're going to use your local municipal attorney to update your code when they don't know anything about the Telecommunications Act, don't bother. You might as well throw your money out the window because the results are going to be the same and you'll have less aggravation. Time and time again, I've seen local governments go to their general municipal attorney. Maybe they'll spend an hour researching the Telecommunications Act. They think they have it down. And if you do that, it virtually guarantees that site developers are going to be able to basically ram a facility down your throat. And if you have the audacity to stand up to them, they'll sue you in federal court and they'll win. It's more important than ever to enact these types of provisions because in the 5G rollout, site developers are more aggressive than ever trying to put these things wherever they want. One of the reasons that's problematic is site developers are a company engaged in business to make money. They don't look to build wireless facilities in the least intrusive location. To the contrary, they look to build them in the cheapest location, and they can say or do most anything. And when they appear before local zoning boards are completely ill-equipped to deal with them. As of now, in most applications I'm looking at, in 90% of the applications, the applicants submit false or materially misleading information. They routinely submit false propagation maps, false FCC compliance report, material misleading real estate appraisal reports, misleading visual impact analysis. The problem is there's no guidance in the code to show the planning board how to recognize when an FCC compliance report is patently false. If you don't put that guidance in your code, you're basically throwing your planning board members to the wolves. They're totally ill-equipped to deal with it. And it's aggravating for me at this point, having handled cases across the entire United States. Many times I've heard applicants mislead local governments. And then when they leave, they laugh at how gullible the local zoning officials were. That's one of the principal reasons I've started to put up these videos, and I hope you find them informative. So you need to have a telecommunications lawyer look at your local zoning ordinance and give you advice as to how to vest you with the maximum power to regulate the placement of wireless facilities, to prevent the irresponsible placement of these facilities and the adverse impacts they almost invariably inflict upon homeowners and communities. So I hope you like this video. To comply with the rules governing attorneys in New York, I have to say the words attorney advertising. Here's more of a disclaimer. Watching these videos is not intended to give legal advice or any specific case. Watching these videos does not create an attorney-client relationship between you and my firm or myself. If you like these videos, please click like and subscribe. I hope you find them informative, and I thank you for watching.